So in this final video on civil liberties, I want to talk about sort of the clash sometimes between civil liberties and the importance of limiting the government and what it can do, um, and the desire for security and for law and order. I'll tell you right now, and maybe you'll just stop watching. This isn't going to be on your exam, but these are some things that I've thought about in terms of this clash between civil liberties, desire for security and law and order, and striking the balance. And I can't presume to tell anybody what they should think, where that proper balance is. Everybody's got their own way of thinking about it. But as a political scientist, I have a tendency to see things where I worry about slippery slopes. And what I mean by that is that throughout history, you can see that during times of crisis, that's when citizens are most willing to permit the government to limit their civil liberties in exchange for security, in exchange for law and order. And that's reasonable. That's reasonable. I mean, depending on your age, some of you may not remember 9/11 at all. Some of you may have fleeting memories of it because you were young. And if you're an older student, you may have very vivid memories. You know exactly where you were when the first and second planes hit the tower. Well, in response to the attacks on 9/11, people were scared. And we're worried that another attack could happen. And so laws were passed that increased the authority of the government, the federal government, to conduct surveillance on citizens. Not domestically, but to be able to track communications between foreign sources and domestic sources. And there was just more of an opportunity for the federal government to keep an eye on what was going on. And again, that's a good thing. It was a scary time. But one of the other things that also happened around that time, and I think I've talked about this previously in other videos, is during the Bush administration, in an effort to collect information and prevent future attacks, engaged in what was called enhanced interrogations, but actually was torture. Now, I understand the motives behind this. President Bush wanted to ensure that there was not another attack, and that he was going to do whatever he could to get information from potential suspects. And so people who were apprehended on the battlefield weren't brought to the United States. They weren't brought to military bases. They were brought to the Gitmo, the base that we have in Cuba. And the idea was, the Bush administration hoped that what that would mean was that the constitutional protections that would be afforded somebody if they were brought to the United States, or if somebody was an official prisoner of war, right, we were in a war on terrorism, they would have certain rights, that this would be some gray area where the government, the United States government, could do things that otherwise we wouldn't be able to do. And I will say that our court system worked, and there were people who sought to protect these suspected terrorists, and eventually these kind of practices stopped. For me personally, the idea that the United States was engaging in torture is abhorrent. That's not who we are, in my estimation, right? How you feel about it may be different, and I'm not judging you, and I hope you won't judge me. The other example of when people are willing to allow limits or accept limits on civil liberties is when there's a feeling that there's not law and order in society. And in this context, I want to talk about the war on drugs. First, I want to remind you that the Fourth Amendment says that there can be no unreasonable search and seizure, no unwarranted search and seizure, that in order for the government, whether it's state or local, to search us either in our homes or on our person, they have to demonstrate probable cause. They have to demonstrate that there's a reason, a reasonable suspicion that they need to search us, and that we can't be arrested except on probable cause. They can't just arrest us because we look like guilty or we look like we've done something wrong. Well, when the war on drugs started to be waged, the police started, and law enforcement started using more expansive methods that some people feel started to infringe on civil liberties. Again, I'm not going to tell you what you should think about these things. That's up for each person to decide. But I want to talk to you about how the courts have handled some of these things. So there's a case in Terry versus Ohio in 1968. Now this is during the Warren Court. So this is during the court where the rights of the accused were expanded. And in Terry versus Ohio, somebody was searched, right? And there was, what the court said is, even though there was no probable cause that this person had broken law, the Supreme Court ruled that the police can stop and frisk people if they think that there's something going on, but in order to protect their make sure that they're safe, to ensure the safety of the police officers. And I'm, again, everybody has different views. I'm a strong supporter of the police. I want police officers to be safe. And so this was one of the rulings that essentially allowed for what's called stop and frisk, that the police can just stop and frisk people, not because they've been arrested, not because they've been charged with a crime, but so that the police can investigate things. In 1991, there was a case called Florida versus Bostic. Okay, and let me just give you quickly the facts in the case. Mr. Bostic was sleeping in the back of a bus, right? The police at this time were boarding the bus and they were doing these drug sweeps that they would do periodically as part of this war on drugs. And so they show up, Mr. Bostic is sleeping in the back of the bus, and they ask him if they can search his person and his bag. And he agrees to do it. And it turns out that he's got a bag of cocaine in there, and he's arrested. Well, when he was arrested, his lawyer argued that that was an unreasonable search and seizure. The police didn't have any reason to search him. He was not suspected of a crime. That they just went ahead and they decided that they were going to search him. The Florida Supreme Court overturned his conviction. They said, yes, that's right. I'm reading from the case. The judge in the case likened the police activity to Germany under Hitler, to living in the Soviet Union, where police will walk onto a train or a bus and ask to see everybody's papers. Well, the Supreme Court overturned that ruling, and they did so on the grounds that Mr. Bostic had voluntarily submitted to the search. Now, I don't know about you, but if a police officer walks up to me and he says, can I search you? I'm going to be scared. I'm going to agree to do it. I don't know what I would do if I had a bag of cocaine on me, but I think most people, maybe you, would agree to it. Well, what the court said was, since they didn't seize him, since they didn't search him, that he voluntarily submitted to it, it was okay. And they said the Florida decision was wrong. Once this decision was made, it made possible drug sweeps of large numbers of people, where the police would go into an area and they would stop and frisk a large number of people. Sometimes they would find drugs, sometimes they wouldn't. Again, I don't know where the balance is between how often police can search us, whether or not there should be some reasonable suspicion that we've committed a crime, whether they can just go ahead and search somebody. This is problematic. In Wren versus the United States, what was happening in that particular case was unusual. And this video is going a bit long, so I'm just going to let it go. As part of the war on drugs, one of the things that the police started doing is they started doing, along with the drug sweeps, they started doing what people call pretext stops. They would pull people over for infractions, driving infractions, and then use that as an excuse to go ahead and search cars. And so in this case, Wren versus United States, this is June of 1993. What happens is this guy, Michael Wren, and his friend James Brown was in the car at the same time. They're stopped while they're driving in a high drug traffic area. Now, the police didn't have any probable cause to think that they were engaged in any kind of drug activity. But according to the police, they stopped at a stop sign, made a right-hand turn, and accelerated quickly without using the signal, and then they were pulled over. When the police got to the car, they said that they saw drugs on Mr. Wren's in the front, and he was arrested. He went ahead. Now, the police were honest. They said, we wanted to search the car because they were in a high drug trafficking area, and these guys look suspicious. So we pulled them over for infraction. Mr. Wren, well, his lawyer, argued that the evidence they found shouldn't be admitted in a court of law because the police, their motive really wasn't to try and ensure that traffic safety laws were followed. They were looking for an excuse to search him. Well, the case went all the way up to the Supreme Court, and what the Supreme Court ruled was that the motives of the police officer were irrelevant when evaluating the reasonableness of that police activity. As long as the infraction was real, as long as he really committed a crime, a traffic violation, again, it's a misdemeanor, which we're not talking about a big crime, that it didn't matter what the motives of the police were, this search was okay, and they upheld his conviction. As the courts are making these rulings, it's basically giving law enforcement sort of carte blanche to use pretext stops and all kinds of things as a way of going ahead and conducting the war on drugs. In this one particular case in Ohio versus Robinette, Mr. Robinette challenges his arrest on the grounds that he wasn't notified ahead of time that he could turn down being searched, that he could say, no, I don't want to be searched. I don't want you searching my car. And in this case, the Supreme Court, the Ohio State Supreme Court, because there had been this increase in the use of these kind of pretext stops to search people, the courts said, look, there's a requirement, an unambiguous requirement to notify motorists that they can leave after they've been ticketed. Because in this case, Mr. Robinette was ticketed, given his warning, the police went back to their car, but they came back and then they asked him to get out of his car, and that's when they did the search. So the court sort of made the same kind of decision that they made in Miranda. Remember the Miranda decision, where now that's why you have to be read. You have the right to remain silent. Nothing can anything you say can be used against you in a court of law, and so on. Well, the Ohio State Supreme Court overturned his conviction and said the police have an unambiguous requirement to notify motorists that they can leave after they've been ticketed. Once that's done, that case got kicked up to the Supreme Court, and the Supreme Court overturned the Ohio State Supreme Court decision. They said people don't need to be notified or informed of their right to refuse a search. But here's the thing. If an individual does say to a police officer, you know what? No, you can't search my car. Does that mean that they're just free to go? No, what the courts have allowed in cases like that is the person can't be arrested, right? But what police officers will do is they'll detain the person for a little bit longer, ask them questions, do other things until a canine unit arrives. And then they have the drug sniffing dogs walk around the car, or if they're trying to search a backpack or something like that. And then if the dog finds that there's drugs in the car, or if they notice that a backpack or a suitcase or something has drugs, then that's probable cause, and now the person can be searched and can be arrested. Now, in the lecture videos, I spoke about the theory of issue ownership back when we talked about political parties. And I talked to you about how the idea about law and order was one of the issues that the Republican Party owns. But I want to be clear about this. Support for the war on drugs has received widespread support on both parties. In the case of Terry versus Ohio that I talked about before, the decision that where police were basically given carte blanche to do stop and frisk, that was an 8-1 decision. Only one judge disagreed with that. In the Florida versus Bostick decision, where the Supreme Court overturned this this requirement that people have to be notified that they don't have to be searched, they don't have to relate to a search. It was a 6-3 decision. Now, it is the case that the most 3 liberal judges voted against this, overturning the conviction. But both the moderates and the conservatives on the court voted in favor of it. Justices nominated by presidents from both parties have, by virtue of their decisions, made it possible for law enforcement to continue to wage the war on drugs. Now, each person has to decide for themselves how you balance out convicting the guilty and protecting the rights of the accused. I don't know what the right answer is. I do know that the war on drugs seems to have been an abject failure. Drugs are still rampant, right? We have millions of people who are in the criminal justice system as a result of all this. Plus, the courts have have been willing to tolerate more and more sort of law enforcement's ability to search people. What's the right answer? I don't know. Right, but a lot of what I just told you came from a book written by a woman named Michelle Alexander, a law professor. And as I read it, I honestly don't know what I think about this. But it troubled me. And so I figured that I would go ahead and present it to you, and you decide what you think is right and what is wrong. How much authority should the police have? How much are we willing to allow law enforcement to do in terms of limiting our civil liberties and our right to privacy and the protections in the Fourth Amendment? Because as I said at the very, very beginning of this, when I talked about the rights of the accused, this was something that was extremely important to the framers of our Constitution. Protecting the rights of the accused. You can look all through the Bill of Rights and you see it over and over and over again. I'm just going to leave it at that. I hope this wasn't a waste of your time.